concerns have been aired. There are also other agencies that assist the president during the recruitment of judges. These are the KRA, for example, the CID. They all make an input. The NIS and the NIS and the Anti-Corruption Commission. All these are participants in the process, so that it cannot be hard to say that he was unaware of what happened during the recruitment. For example, one concern has been raised that NIS refused to give JSC the information which they had on some judges which they considered negative. They just said, we don't consider this as worthy appointees, without saying what information they have against them, so that these judges would have been allowed to also clear the air over any allegations regarding them. Because now NIS was going to appear like the old outdated special branch, which would make very negative comments about people without giving them a fair hearing. And that is what has gone wrong. The other matter I would like to refer to is implementation of the Constitution. The implementation of the Constitution, even now, lags behind by very far. Particularly for us, legal practitioners are frustrated because critical legislation like the Evidence Act, the Civil Procedure Act, the Criminal Procedure, and the Penal Code have not been implemented up to now. And this has frustrated litigation. And this is part of what hampers judicial independence, because there is not enough mechanisms to address disputes resolution within the courts. So it is important that even as we consider further reforms in the Constitution, we should also allow, rather agitate for the Office of the Attorney General and the government to implement the current Constitution. What has gone wrong with the JSC? The JSC has not been transparent in its work, both in regard to display the proceedings among the judges and in regard to recruitment of judges. And this has brought a lack of confidence in their work. Because we have seen, for example, that there are even proceedings, disciplinary proceedings against judges, but we never hear how the process is going on. They take very long to complete those proceedings, so we don't know, and this has brought a lack of confidence among Kenyans. So what should we do to enhance first the independence of the judiciary? Should we restructure the JSC? I say yes. I think we had been too encouraged by the JSC at some stage that we were too ambitious in the current Constitution to give JSC most seats, judges rather, most seats within the JSC. We had looked at the Constitution of Uganda, for example, where they had said that, rather, they enacted provisions which said that the Chief Justice and judges cannot be members of the JSC, so that the chair of JSC would be maybe a retired judge or a senior advocate and other lawyers together with members of the public. And that has worked very well because there is some transparency in that arrangement. So what needs to be done is to remove judges from the JSC. Maybe they can retain one judge to look at their interests. But the rest of the members should be advocates, members of the public, and so on, so that the JSC can be restructured to make its operations transparent and to give confidence to Kenyans. What about the AG? Should the AG continue to be a member of the JSC? I say no. Because the AG has brought all these problems within the JSC. The AG sits on the JSC and is part of the decision-making process. But after making those decisions, he goes and maybe misadvises the president. Because I remember, with regard to the appointment, I am the one who went to court on behalf of no side of failure to try and get an order against the president to swear in judges. The AG, by then it was Professor Bill Mugai, but I don't refer to the AG as a person, it's an institution. The AG went back to court, and he had been part of the JSC, went back to court and contested that decision. And it took us some time to get an order that the failure by the president to swear in judges was unconstitutional. And that is how we ended up swearing. Now we are confronted with the same problem once again. And the AG is still party to the problem. So when we are considering amendment of the Constitution in regard to the judiciary, we must be firm that the AG must be removed from the case. If the executive wants somebody else to protect their interest, maybe the person you should consider is the CS Treasury. Because as part of the government, he is able to advise the JSC on the budget available with regard to appointment of judges. Because I heard the president also saying that the amount of money allocated for recruitment of judges is not available. So maybe if we could put the CS Treasury there, he would be able to advise the JSC on what is available and what is not. What else needs to be done with regard to independence of the judiciary? The judiciary, of course, must be alive, that it is also on course to ensure that justice is done and justice is seen to be done. That is by ensuring that the operations are transparent, that there is delivery, that there is no delay in hearing cases, that they try and look at the backlog so as to give Kenyans confidence in their work. And the only way to do this is to ensure that the operations are completely transparent. What about the judiciary fund?
You're making very important points regarding the independent judiciary, and also making a case for restructuring and having the structure of the JSC amended. Now, I think talking about independence, there has been debate on the issue of budgetary allocation to the judiciary. And the CJ, in one of his press conferences, has actually complained of how the resources that are met to the judiciary are constantly being reduced to a point where they are not able to do or to discharge their functions. He says that the highest that the judiciary has gotten is 0.99% of the national budget. And this year they have been allocated about 18 billion, which is 0.67% of the national budget. But we are asking, in order for the judiciary to be said to be financially independent, can we make a case where we can ring-fence a certain percentage of the national budget to be credited to the judiciary fund every year, and to ensure that the judiciary is financially independent and the amount due to the judiciary is guaranteed by the Constitution?
Thank you. Maybe first let's start with the judiciary fund. And this is another area of failure to implement by the executive and the office of the Attorney General. There's an article in the Constitution that creates a judiciary fund, but up to now, those provisions have not been implemented to date. So the first point of call should be to try and address the AG to ensure that that article is implemented. With regard to the now, I think, historical question of budgetary, rather lack of proper budgetary allocation for judiciary, this has been a problem between Parliament and the Presidency and the Judiciary, which ensures that, rather makes it impossible for the Judiciary to have a budget that reflects its activities. What can we do? I have thought about this, and I think now that we are at the point of implementation of the Constitution, regarding the enacting new provisions in the Constitution, maybe we could now settle this question once and for all, and provide for a percentage to be allocated directly from consolidated fund to the Judiciary. That is what we did, for example, with regard to devolution. We provided that it be pegged at 15%. We could also peg this upon the Judiciary, maybe between 5 and 2.5%, to ensure that the operations are no longer clogged by Parliament and the Executive.
Thank you very much, Senior Counsel. Thank you, co-moderator. Direct question to Honorable Martha Karua. On the issue of your experience having served in the public and also being the first cabinet minister then for Justice and Constitutional Affairs to quit on the grounds of frustration and ability to deliver your duties, including the question of appointment of justice. Based on this experience, and now evaluating and picking up from Senior Counsel the continued impasse between the executive and the judiciary, how do you think this tension can be best addressed? How can we surmount for the benefit of the people of Kenya?
Asante. For me, it is not about changing the law. It's about each of the arms of government understanding its role, that they are independent, but mutually dependent. The three arms of government are all independent, but they are part of a jigsaw puzzle. They are part of the whole. Government cannot be whole without any one arm of government. Once we agree that, then it is up to the leadership of the three arms of government to ensure that they operate independently, but they also cooperate with one another as necessary, without eroding their independence. We have had, you will remember the judiciary, immediately the Constitution was promulgated. We didn't have problems between the executive and the judiciary. But before then, there were still problems we encountered during my tenure in appointments. But in that case, the problem was not between the judiciary and the executive. In fact, the executive and the judiciary were on the same page, but there were problems between my ministry and the presidency, because where the act says that I advise and the advice is not taken. I therefore want to say that even after the promulgation of the current constitution, there is something that we are still not doing right in judicial appointments. The background check and all those other things. And I think in this case, Nzamba has more information than I have on what has gone wrong. And it would appear that the executive has failed to give full information to the JSC, because they must share information. But what if the information is being availed after the appointment, the recommendation of the appointments have already gone to the president? I was looking at the JSC Act, and I realized that the JSC, if credible information is brought before it, by any quarter, not just by the executive, by any quarter, they can actually re-examine their list. Section 20 talks of death or incapacity. And incapacity includes legal incapacity. But when the executive gives incomplete information like X is not suitable, the judiciary, the JSC must not open, because then the executive is trying to control by determining who is suitable and who is not. The sharing of information must be candid, open, and facilitative. And I'm just wondering if there is a problem, because these are not facts within my knowledge, it's what we are learning from those who know. If there is a problem, say, in 1 or 2 appointments, why would there be a standoff for 41 appointments? Why can't the 2 institutions have sat and seen how to proceed, or taken time like 2 weeks to complete thorough investigations on whatever allegations? It is very unfair to hold the country ransom, because that is what is happening by failing to appoint. But I belong to the school of thought that believes that both the JSC and the president, in his role of appointing, must operate under the Constitution, under the law. Both are enjoined under Article 3 to uphold and defend the Constitution. So if any one of them has information about any incapacity in the appointees, they cannot proceed blindly. But if then you are failing to proceed and you are not handing over information, then we suspect your motive, that whatever you are having may not be really information. Your motive is to derail the appointments. So what I see is a failure of leadership. For instance, the Chief Justice complains that the president refused to give him an appointment. That is a failure of leadership on the part of the president. The authority the president has, the authority the Chief Justice has, is not personal. It's a trust on behalf of the people of Kenya. None can refuse to see the other, even when they feel they are not friends. They are doing a public duty. They must sit and they must perform their duties efficiently. I think that the cure to the current stalemate is remembering each of the parties concerned, remembering their oath of office, and sitting down to resolve the issues. But where the matter has gone as far as court orders, unless if there is an order of stay, then orders must be obeyed by all. The Attorney General had a chance to defend the government in court. If the court did not agree with him and he was aggrieved, he's at liberty to appeal and to ask for stay. So we must all be seen to be following due process. But I want to go back where I started. This case demonstrates a serious issue of failure of leadership by those placed at the helm. When it comes to the funding of the judiciary, I do not think we should be talking about a percentage. Imagine if each arm of government asks for a percentage, because budget making is balancing the interests, balancing the needs and the priorities of the day. If everybody asks for a percentage, there are departments or there's an arm of government that will get more than they need. And that is what is happening. Parliament is overfunded. The judiciary is underfunded. What we need is not a change of the law, is the manner in which we are doing business as Kenyans. We are doing business as people in authority. Percentages will not be the cure. I think I want to leave there, unless if there's an issue, the moderator thinks I should clarify.
Much Honorable Madam.
if you're not talking about the percentages of 2.5% or whichever percentage that may be put in place, what other measures can be put in place to ensure that the finances due to the judiciary are guaranteed, and you do not have this back and forth between the CJA and the president? I also want to take you to a further question. In your address to members of the Law Society of Kenya in Malindi, and also an interview that you did last year with a leading media house, you made a strong case for delinking of the JSC from the judiciary. Maybe you can also share your thoughts with our audience in regard to delinking the role of JSC and the judiciary. Thank you. Welcome, Mother.
I think there I share my thoughts, I share the thinking of my learned senior Nzamba Kitonga, that the Chief Justice should not necessarily chair the JSC, but he should be part of it. I also believe that the Attorney General should be part of the JSC. You do not cure by excluding. You cure by including. And though we may have difficulties with a certain holder, you can't throw out the baby with the bathwater. It is not all days that we shall have people appointed who are going to be a problem. We should find a way of overcoming the problem without causing unnecessary divisions between the three arms of government, which, as I have said, must work together. I agree that a senior lawyer or retired judge should chair the JSC, but the Chief Justice should be still head of the technical committee that recruits, because you cannot delink the personnel need from the head of the institution, because that's the person on behalf of the institution who knows best the needs of the institution. I was thinking more of a model, more like what happens in the UK, where you have a body that is not chaired by the judiciary. When it comes to also issues of remuneration, it is better when such a committee is shared by other people, not members of the judiciary. The same for Parliament, so that public interest is taken into consideration when those issues are being thought about. These are matters that we should examine and debate, but I do not think that we can have good debate at a time when there is unhealthy tension. And tension is a feature of check and balance. And tension is ordinarily healthy. But when it goes to the level that it has gone, where there is underhand ways of demonizing the judiciary, because that's what I've seen in the recent past through the social media, then that tension is unhealthy, and the casualty is the administration of justice in this country. And the executive must know that it cannot function without a judiciary that is up and running. Parliament must know that the authority they have is not personal for them to throw their weight to deny the judiciary funds. Because in the recent past, Parliament and the executive have conspired to deny judiciary sufficient funds. But having said that, the judiciary, just like all the other arms of government, their spending is not prudent from where I see it. They also spend lavishly. When they are constructing the courts, it is lavish. I think we also need to return to efficient use of public resources. But having said that, the government must fund, the executive rather, and Parliament must adequately fund the judiciary. But I do not think that a percentage is the solution. It should be on need basis.
Point on issues of transparency and accountability in public resources, mainly from the judiciary. And my next question goes to Mercy Ndeche. Back again to the question of transparency and accountability, specifically for the Judicial Service Commission. If we look at the recruitment processes, should the deliberations on the appointment of judges be open to the public? The deliberations, not the recruitment, not the shortlisting, the deliberations, as is the case in South African jurisdiction. Would this then cure the current executive mischief that we have witnessed and observed, particularly now that has caused the impasse on the appointment of judges? Welcome, Mercy.
Thank you very much, Elsie. And let me say that I am delighted to be here. And I think this discussion that we are having is very timely. It is important when your allies call you to tell you what is wrong with you. So it is something that I am taking very positively. And remember that even last year, like now, we had gathered together as stakeholders again to hear what is wrong with us. Even Jesus himself asked people, who do people say that I am? So it is important to get to hear what people say that you are. Then when they think you are not what they are saying, we can have a discussion. So this discussion is very healthy. It's certainly better than the banners we are seeing over flyovers and other places in the streets. Because when your ally tells you what is wrong with you, then you know, because they answer the question. Elsie, let me just say that the issue that my senior Nzamba was talking about, the reconstitution or relooking at the composition of JSC, it is a discussion that I have had with him even away from this forum. But I was a bit perturbed when I heard him now mention our neighbor Uganda as the new role model of a constitutional democracy. That really perturbed me, because I think the eyes should be on the opposite side, not looking to Uganda. Then the other issue is that it is good to relook at existing structures, but when again you think of, when one says that we should even have the CS Treasury on board, and we are already having problems with the executive, and we are looking to increasing more executive in the JSC, that also perturbs me. And the other issue I always say is maybe we need to identify the mischief. When we say there are too many judges and judicial officers in JSC, and I'm not holding their brief because I'm not one, then we should be able to say they have done X, Y, Z, or they are not able to deliver X, Y, Z. Identify the mischief, so that we are not just talking from a point of feeling, assuming that because they are judges and judicial officers, then they are not able to deliver or to offer oversight. If we are saying there's a problem with recruitment, then we point it out. If we are saying there's a problem with discipline, and we point it out. And I may dare say that the JSC is the only organ in the entire country that dares to discipline even from the highest, from the Supreme Court, even the DCJ and the Supreme Court at all levels. With the other arms of government, you'll hear about stepping aside without you don't know what happens next. But now to your question, Elsie, on about whether the deliberations of JSC, and I believe you are talking about the post-interview deliberations, should be made public. Let me say this first and foremost, that the quagmire we are in, the stalemate we are in, has nothing to do with the opacity of the process post-interview. It has nothing to do with that. And I normally I'm looking at this stalemate from a historical point of view. It has been intermittent. It has been happening intermittently since 2011, from the days of the retired President Kibaki, and all the way up to currently. So we should not be looking at it as an isolated incident. For me, it is a situation of the executive trying to push the envelope consistently, persistently. And I was looking at the number of judges that have proclaimed themselves on the issue of Article 166, because that is a problem article, and they number not one, not two, 15 voices telling the president, this is your role when it comes to appointing the judges. But the voice has remained unheeded. And although the remedy of not being satisfied with a decision is appeal, in this case, we are facing defiance. So let us contextualize where we are. It's not a one-time off. It happened in 2014, it happened in 2011. It even happened in 2016 when the parliament had tried to sneak in the three names, the issue of the three names, and the court came back again and said, no, you cannot do that. Article 166 is clear. So let us put it within the context of history and deal with it that way. When it comes to the recruitment process of the judges, there is no system which is 100% perfect. And these systems are our systems. And it is through engaging that we can improve them. But I dare say this, Elsie. From where I sit, again, the recruitment of judges is the most transparent. In fact, it is the best compared to other arms of government. And I will not, it's not that maybe I'm not comparing with the best, but it is still the best. Most of the times we get to know people have been recruited when we see them being sworn in. In between, nobody knows what happens. And the reason why it is so, it is because it is provided for very clearly in JS Act. The JS Act provides timelines and even provides even the issues, the questions you should engage a candidate on. And when it comes to the issue of receiving complaints from members of the public and government and non-governmental agencies, what happens is that when these issues or information, when the information is brought forth, it is not even left to the secretariat. We have a commissioner in charge who looks at the information that has been brought and distills the information and then engages the candidate. And you know, the good thing with the JSC interviews is that although the Act says they should be public, they're actually live. They are televised live, such that if a government agency or a person, any individual, has brought information which has been ignored by the JSC, then they can see for themselves that I said X, Y, Z, and when that candidate was being interviewed, they were not asked. And then they can raise the issue thereafter. The other issue is that when you look at Section 30 of the JS Act, it states that the panel that should interview judges should comprise of at least 5 commissioners. But what has been happening in practice is that all commissioners interview judges, and the chair is normally the Chief Justice. And this is to disabuse the speculation that may arise, wondering why these 5 or why is this constituency, has this constituency been left out? But with regard now, zeroing on your question as to whether the deliberations, which to me are just the score sheets, the marks and the score sheets, should be made public, we have 2 impediments. By the way, from where I sit, I would have no problem disclosing the marks that I have given or the scores I have given a candidate. I would have no problem with that. But we have 2 impediments. The first one is paragraph 5 of the first schedule of the JS Act. And it has stated a host of information that must remain confidential. And because of that, the JSC cannot disclose, the hands are tied by that particular paragraph. And secondly, this matter has been deliberated on in court in the case of Omutata, one of his many cases, Omutata versus AG and JSC. And Omutata went to court after the recruitment of CJ Willie Mutunga and the DCJ Nancy Baraza, and wanted disclosure all the way from shortlisting to the end. And Justice Musinga handled that case, and he said that it is not prudent to disclose that kind of information for two reasons. One, it might infringe on the right to privacy of some candidates, and then secondly, it might also affect their professional lives. I mean, if you are scoring very low and it is out there in public, it might really affect. So the jurisprudence of this country has tied the hands of the JSC, but as you rightly said, in South Africa recently in 2018, they allowed, or the Constitutional Court allowed the JSC of South Africa to disclose, to make disclosures of their deliberations. But that does not mean that whenever individual candidates write or call to seek information on why their application was handled in another way and not in this other way, especially during shortlisting, the information is normally given, but to individual candidates, not to the public.
Thank you, Mercy. I think the question has been very well answered, and you took the opportunity also to respond to other issues that have been raised by the panelists. I want to bring in the LSK president, Nelson Happy, at this point in time. LSK has been the forefront in defending the independence of the judiciary and calling out the executive for undermining the independence of the judiciary. And this has included taking legal action, like in the matter that our senior here acted in 2014, and recently in the case of Adrian Kamodo. Your council has now taken a unprecedented step where you have sought to expel or to remove the AG and the Solicitor General from the role of advocates. The question is this in itself a silver bullet? Will it resolve the impasse? And even if this motion succeeds, what next after the members deliberate and make their views known on the motion? Nelson.
Thank you so much for giving me this opportunity to address an issue of great concern to the Kenyan public. And it is of great concern not just to advocates, but to all Kenyans, because access to justice is a right that is due to every Kenyan. Courts of law are comparable to hospitals, because everybody will need the hospital one day or another, be he or she mighty or meek. Let me just trace the history of the tensions between the executive and the judiciary over appointment of judges. Let us look at the case of Marbury versus Madison. The case is well known as the locus classicus for administrative law. However, there is a facet of that case that has never been discussed fully, is the political implication of that case. This was a matter where President Jefferson, upon assuming office, did not want to take on certain judges that had been recommended for appointment immediately before his ascension to office. And the court then handled the matter very effectively, to the effect that as soon as the recommendation had been made, there was nothing more that had to be done by the executive to effectuate the appointment of a justice there. If you look at it from that historical background, you realize that the problem we have here in Kenya is the problem that bedevils everybody who ascends to the office of president. However righteous, however democratic that individual may be. You've seen the case in Malawi where a professor of law has initiated steps to remove the Chief Justice, ostensibly because the Chief Justice made a decision that was not favorable with the President of the Republic of Malawi. But what really is the problem? Is the problem the seat or the person on the seat? How did we get here? Let us look at the deliberations of the first Judicial Service Commission upon the promulgation of the Constitution. Who was the Attorney General? Who are the members of the Judicial Service Commission? How did they conduct themselves? How did the President of the Republic of Kenya deal with the JSC then? Remember, Amos Wako was the Attorney General when the first Judicial Service Commission started its work upon promulgation of the Constitution, the representatives of the Law Society included Mwangangi and Ahmed Nasir Abdullahi. Look at the manner in which these individuals conducted themselves. How did they confront President Mwai Kibaki when he unilaterally and in disregard of the Constitution attempted to appoint retired Justice Al-Nashir Misra as the Chief Justice of the Republic of Kenya? How did the court handle that matter? How did the President act? How did the National Assembly act? Remember, Speaker then, Kenneth Marende, took a very firm position and said the National Assembly will not countenance what the President of the Republic of Kenya has done. Courts weighed in, and in a decision, I believe it must have been given by Justice Mohammed Ibrahim, if it's not Justice Musinga, said this process must be put to a halt. And the President, as well as the Attorney General, obeyed the court order because they understood in a constitutional democracy, the rule of law is fundamental. As soon as that was done, and came in the administration of President Uhuru Kenyatta, several attempts were made to interfere with the independence of the judiciary. The first attempt, you remember, was the refusal to appoint judges who had been recommended for appointment. This matter went to court. The court made a directive that the refusal to swear in these judges was unconstitutional, and the President complied with the order of the court. The second attempt was made when the then Attorney General, or I might say the Solicitor General, because the Attorney General dissociated himself with that exercise, put a bill in Parliament for the amendment of the Judicial Service Act, the effect of which was to give the President of the Republic of Kenya a choice of 3 names for appointment of the Chief Justice and the Deputy Chief Justice. Again, this matter went to court, it was decided, then the President obliged, the Attorney General obliged, and they let the matter go. We're now in a situation whereby 41 judges have been recommended for appointment. The Attorney General of the Republic of Kenya has come out and said, in his own words, that the action of the President refusing to swear in the 41 judges is based upon his legal advice. And his legal advice is founded upon information which was given to the President of the Republic of Kenya by intelligence sources. Nobody knows this information. It will appear that even the Attorney General himself is not privy to the information that is in the mind of the President. Is that the manner in which the Constitution intended that the functions of the government of the Republic of Kenya will be conducted? I highly doubt so. Now, the Law Society of Kenya has taken what may appear to be an unprecedented step of commencing proceedings to expel the Attorney General of the Republic of Kenya as well as the Solicitor General on account of misbehavior on their part. What we're doing is not new. It's been done in Uganda. I believe it must have been done in the Commonwealth, time without number. What do we intend to achieve? Will we achieve it? If we achieve it, how best will we make use of the decision by the membership of the Law Society, expelling these 2 members of the society from the society? Is it a silver bullet? Are there other avenues we seek to pursue to ensure that these 41 judges are sworn in and this does not repeat? You saw what happened in Uganda when the Law Society of Uganda took that action against the Attorney General. It passed a strong message that much as the Law Society does not have the power of removing the Attorney General from office, it has the right and the power to remove the Attorney General from the membership of the society. And this is intended to pass a message that you cannot ascend to an office which is based upon your qualification as an advocate. Then when you arrive there, you fail to uphold the Constitution, yet it is your obligation, first as an advocate, and second as a state officer, to uphold the Constitution and to defend the rule of law and constitutionalism. It is our expectation that members will make the correct decision come the 23rd of July, when this issue will be brought to the floor of the AGM. But there are other means that we seek to adopt to ensure that this issue is never repeated. First and foremost, there is the possibility of us initiating a constitutional amendment to ensure that the Constitution is amended in order that the function of swearing in a judge recommended for appointment is removed from the president. There are many countries where this is done by the Chief Justice. Let this also be done by the Chief Justice of the Republic of Kenya or any other senior-most judge immediately before the Chief Justice, in the event that the Chief Justice will not be there to do this. We have also intimated that the Council of the Law Society of Kenya, in a decision made on the 11th of May 2020, recommended that the National Assembly should take up this matter and see whether or not the President of the Republic of Kenya has violated the Constitution. We may also want to implore the judiciary, in particular the Chief Justice, to deploy more drastic measures, because the biggest beneficiaries of the court process are the mighty. It is the executive. So that if the executive will want to use the court process to facilitate criminal investigations, issuance of warrants of arrest, issuance of warrants of search, issuance of freezing order, and many other processes that are peculiar to the executive, why should they be given preferential treatment? Why should they be given an opportunity to come to court to facilitate the performance of their obligations, yet they don't want to comply with court orders? We will soon enough ask the judiciary, we will also ask the membership of the Law Society to boycott these processes, so that if it is a matter instituted by the Office of the Director of Public Prosecution, Asset Recovery Agency, Ethics and Anti-Corruption Commission, Kenya Revenue Authority, will want to boycott those proceedings so that the courts are able to defend themselves, and the courts must be firm insofar as this issue is concerned, because whereas we've come out to help the courts, they must also defend themselves. And what better way to defend themselves than to ensure that the authority is asserted? There are many court orders directed at the executive, parastatals, state officers, public officers that have been disobeyed. As the Law Society of Kenya, we have asked the public and advocates to submit to us all those orders that have been disobeyed. Indicate to us what steps have been taken subsequent to the making of the order. Have there been content proceedings that have been commenced? What is the outcome of those content proceedings? If it's a money decree against the government, have you initiated proceedings in the nature of judicial review to compel the payment of these decrees? What has been the outcome of those proceedings? Give us all this information. We want to compile a register of all these court orders and commence litigation to declare any state officer, any public servant who has disobeyed court order as unsuitable to continue serving in public office. Of course, there are those who will say, but the ultimate appointing authority, which is the executive, will determine whether these individuals will continue being in office. That may well be so. But remember, these officers will not be in public office in the nature of appointing office forever. They may want to go for elective offices. The elections are not far away from now. Failure to obey court orders has an impact on Chapter 6 on the integrity of these individuals. When they submit their names for election, the people must evaluate What is the history of these individuals? What did they do when they were cabinet secretary in charge of interior? What did they do when they served as the Attorney General of the Republic of Kenya? It is only by enlightening the public, by taking these positive steps, though drastic, that we are able to create change, that we're able to find a solution. Because the way I see it, the problem is not the seat. The problem is on the person sitting on the seat. And how do you resolve the problem? You don't resolve the problem by removing the seat, because when you propose that we amend the Constitution to remove the number of judges sitting in the Judicial Service Commission, to exclude the Attorney General from sitting in the Judicial Service Commission, we're addressing the seat. We're not addressing the person on the seat. And we have indicated with so much evidence that there are individuals who have sat in the seat of the President of the Republic of Kenya, who, though not agreeable with the decision made by the court, a decision made by the JSC, have nonetheless complied because they understand that it is their obligation to do.
Mr. President, I don't want to cut it short, but I need to bring in the chair of the ICJ Kenya to continue the discussion. I will bring you later if time allows. Let's at this point in time, let's give our chairperson, Kevin Mugeni, a chance to deal with the issue of civil society. You know, a few years back, civil society was labeled as the evil society. These days, you are seeing the very same people who labeled civil society as such are now asking, where is the civil society as this, as the Constitution is being breached by various organs of government, including the executive. So, Kelvin, what is the role of civil society in trying to resolve the impasse between the judiciary and the executive?
Thank you, Patrick, and thank you for having me today. The civil society has been in the forefront in fighting to support institutions that promote and uphold the human rights and democratic governance and justice. This has been going on, and we did this during the multi-party struggle for the multi-party democracy in Kenya. We did that in the run-up to the 2010 Constitution. And we have been doing that as we speak currently. We have been, this part of the process we are doing to ensure that our community upholds the rule of law. As ICJ properly stands for a just, free and equitable society, the question that comes to the forefront is what do we do as civil society to promote the rule of law? And I'll tell you this, in the last couple of years, what we have been doing is to ensure whether we can have this equitable access to issues that are being done by the government properly. And the civil society, though we have had this issue of this shrinking civic space, we've done quite a number of interventions as ICJ together with our partners. The most important is that whenever issues like this have arisen, what we have done as ICJ is that we have sought, in the first place, we have sought litigation, public interest litigation as part of the process to resolve these issues. We have also done what we do, a strategic partnership with the government and other players, especially when we want to have a change that is proper, especially when you want to have the laws or the just laws that we have to ensure that there is a proper protection of fundamental rights or human rights and the security of the person. What we do, we seek various interventions. As a civil society, we can either agitate in the public, we can seek collaboration and to have interventions done by various parties. But what is most important is to bring it out to the public so that they can be able to understand what is it that the government is failing to do. We understand, all of us, that the most important issue that the public needs to know, especially Wanjiku, is what does an open government do in ensuring that there is proper enactment of laws, there is proper administration or enforcement of issues and accessible, fair and efficient issues that are being administered by the government. what we do is that we synthesize Wanjiku to understand that she has a right to have a proper and fair administration, and that whatever that has been done is enforced or enforceable properly and is accessible to the public. When we have done these interventions, whether through communiques, whether through active involvement with the relevant agencies, it's because it is a duty of the government that we have to remind them that the issues about the just laws, proper governance, and that issues like justice is accessible to all, timely, ethical, competent, independent, and neutral. These are issues that we do when we collaborate with the relevant agencies to ensure that as civil societies, we're able to bring it out in the open and show where there are failures on the part of these government institutions. Failures, we mean, it is not only the government as the executive. Failures include the legislature and the judiciary itself. When you talk about the legislature, when they fail to enact the proper laws that are supposed to ensure that there is good and just governance, then it is upon us to ensure that either we go to court and ensure that those legislations are declared unconstitutional. If there is failure on the part of the government to implement, for example, the judicial fund, we are in court. In fact, I shouldn't say much on this because the matter is coming up in court tomorrow on the question of whether the judicial funds will be implemented or to what extent it can or it's not being implemented. That is an issue that as a civil society we have to, when it all fails on the part of the government, we have to point out where they are failed. When it comes to the judiciary, we work with the judiciary sometimes when to ensure that there is accessible justice available to everybody. And when we do so, it is our duty to ensure that we remind them that justice that Wanjiku requires, it's not just because it has to be timely, it has to be also ethical, and it must be dispensed by competent persons. But in all this, when you look at all these arms of the government, the most important thing that civil society we always try to do, and we must remind them at all times, is that there must be accountability. And everybody must be held to account. And these issues, when we talk about accountability under the law, it is not just on the question of the judiciary or the legislature or the executive. All those bodies must be held to account for their actions. And that's why we say, as a civic society, we try to remind them that between the legislature, the executive, and the judiciary, there is interdependence. Whereas we talk about there is separation of powers, there must be interdependence between these organs so that they understand what is their role within the constitutional dispensation of this country. We understand, if you look at Article 2, all this authority that they are exercising belongs to the people. But we are doing so, giving it to them to do it on our behalf. So we remind them that they must at all times remember that there is certain level of interdependence and independence. And when you talk about interdependence, means the judiciary should not act in a way, they should not forget that they're dependent on one way or the other with the legislature, because the funding that must come from the legislature is given by the people. It must be audited, it must be accountable. It must not be given as a free pass for people to spend and abuse. Same thing with the executive. We understand, and this must be remembered, that the process of appointment of judges is not a sole responsibility of the JSC, because there is an interdependent process that must be undertaken. And by this, I say what? When you talk about accountability on the part of the judiciary, when the JSC receives complaints in terms of there is discipline required to be undertaken on the part of its officers, the person who appoints this tribunal is the president. So the question I will pose, and this is an issue that has been raised severally. As civil society, we believe that the question of competency of judges is paramount, because to have someone who is not ethical, who is not competent, is abusing Wanjiku. And when we say this, we don't expect ethical issues to be raised in banners around the streets and elsewhere. There is a process that has been set, because as an organization, we believe that everybody is entitled to due process. If a judge or the allegations are made against a judge, due process requires that this person must be made to go through the process set out in the Constitution for removal of a judge. And I believe that it is unethical for the Attorney General on his part, if he believes or he has information that there is a suitability questions on some of the judges, the most basic and logical thing to do is present the evidence before the Judicial Service Commission. And because I'm saying this, out of the 11 persons who have been nominated to the Court of Appeal, 10 are serving judges of the High Court. You cannot stand as a former judge of appeal to state that we have information of certain persons who are not suitable, and you walk back to your office when you know that the process that is required to be done for removal of that person is provided for in the Constitution, and you have not undertaken that process. It is very unfortunate that the Attorney General, knowing that there is a due process that ought to be done, has not undertaken that process. I'm saying this because when you talk about accountability, he must be accountable for his own actions to ensure that he has complied with that process that is required to be done. Unfortunately, that has not been done. As civic societies, we must always come out and ensure that this is put to them, and if necessary, we can also go back to court. But if that's not possible, we have tried as much as possible to remind them their duty as provided for in the Constitution must be adhered to. So these are processes that we cannot forget that, and this must be reminded to them that the Attorney General, the President, the Legislature, and the Judiciary are all accountable within the constitutional dispensation of the country. They must operate within the Constitution. And with that, you cannot forget that constitutionalism requires that the law that set you in that office, if it's not obeyed, then you're not fit to be in that office or to remain in that office. That's why we say accountability is for everybody. There is nothing about having individual accountability.
Yeah, thank you, Chairman. Thank you, Chairman. We have several comments with respect to your presentation, including one from Senior Counsel here. And we have a comment from ICJ member, Don Dare, writing in from Arusha, specifically looking at your issue you've raised around accountability mechanisms. He points out Article 240 of the Constitution that says there are created mechanisms which include the National Security Council, the AG, who is a member of that council as well, Article 239 that defines national security, Kenya Defence Forces, National Intelligence Service, and National Police Service, which the Constitution obligates these organs not to act in a manner that is partisan. So that's a comment from Don Dare, writing in from Arusha. But a further question for you, Chairman, which you can contemplate as we go into the question and answer session on behalf of our participants. And participants, is to remind you, keep talking to us on Twitter, on our Facebook accounts, and on our, keep sending your comments to us on the Zoom chat, as also on Facebook, so that we can pick them up. We have a couple of questions, and I will invite Senior Counsel to raise the question first, and then invite Patrick to also ask questions on behalf of the panelists. We have questions from Mercy, Martha, including the President of the Law Society, Nelson Harvey. So over to you, Patrick, to ask we start with Senior Counsel to ask the question, and then to Patrick. Thank you.
Thank you, Mr. Chairman. There are concerns in the public that civil society is dead because they are no longer, their voice is no longer being heard in relation to very many questions that afflict the nation. We used even to have demonstrations by civil society, for example, on a big issue like this of appointment of judges, but their voices are unheard of. Can you enlighten to us what is happening to civil society? Is it state capture? Or is it failure to abide by their role? Thank you.
Thank you, Senior Counsel. Patrick, you had a question?
Yes, we have a question from Millie Luanga on Zoom, and the question is directed to the Senior Counsel after Kelvin answered his question. When asked, the Constitution provides for a structured way of engagement and resolution of issues in as far as devolution is concerned, and the two houses of Parliament are concerned, is there a gap when it comes to the relations between the arms of government, that is judiciary, in this case the judiciary and the executive? There's also a question to Dr. Mercy Deche from an anonymous person, he has said, Patrick, please ask Commissioner Dsc about allegations that there are commissioners appointing judicial officers after receiving inducement to satisfy political interest. Is this linked to the lack of transparency area mentioned? And Mercy, well, at that, you will also address the issue of the Judiciary Fund and why it has taken 10 years after the promulgation of the new constitution to operationalize the fund. So I think the chairman goes first. At this point in time, we need to be very concise and to observe time so that we finish this webinar within the time that is specified. Chairman, please, very briefly.
Yeah, thank you, Patrick. And I'll say this: some civil societies, yes, may have been captured, not ICJ. You can see part of the issues that we're dealing with today is part of our work, and I think we can exemplify this: that our strategy has changed. It's not necessarily that we must be at the streets throwing stones. We are going beyond the question of throwing stones to now dealing with the issues more affirmatively, and in terms of being more proactive and ensuring that we have change that is real. One of the issues that I can tell you, Zamba, that we have done as civil society and as ICJ also, you look at questions around access to justice, questions around decriminalization of petty offenses, questions around right to information, questions around standing orders around the counties and legislation that we have been working. We come to issues like extractive issues that we have been working on. The issue is the civil society under the 2010 Constitution has been more proactive, doing things that are real than working out in the streets to throw stones without real change. What I can say is that as a civil society, we have been able to have more change that is meaningful and real for Wajiku, rather than ensuring that it is more for the very few who can benefit from that. And I think you can talk about right now, when we work on questions of social and economic rights, we work around the question of how do we benefit the society more, and how can the government be responsive to the issues that we raise as civil society. Just as I'm saying that, I needed to just highlight one issue on the relationship between the various arms of the government. I know that under the Judicial Act, we have the NCAJ, which deals with the questions between the justice sector players. And I think the law ought to have been done saying that between the heads of the legislature, the executive, and the judiciary, they have these common meetings that can resolve this impasse between them. And I think when you hear that the Chief Justice has not been able to meet the President and they're not communicating, it means that the lines of communication which are supposed to be existing do not exist, and that they're not properly legislated for them to exist. And the body that ought to be doing that is not there. And I think the most important thing that we need to do is to ensure that we have proper channels of communication that properly set out and highly articulated to ensure that the communications, whenever such an issue is, are properly addressed and not resorting to the media. It shows that there's something missing to result in the media. And one thing that I needed to point out, which maybe was not raised, although it was said by Dr. Mercy, is that when you see banners are being put up in the streets, defaming members of the judiciary and other persons, I would have expected the DCI or the DPP to have commenced investigation without prompting, to ensure that those people who are responsible for those social media messages and banners are prosecuted. But having said that, it may be that the way people are saying that the information is coming from people who know somebody is doing it, I think it is important to dispel that rumor and ensure that the proper culprits are brought to book properly. Otherwise, if they fail to do so, we have issued notice. We'll move the court to ensure that those banners, investigation of those banners are done and those who are responsible are prosecuted, whether in private or in public prosecution.
Thank you, Chairman. In fact, on your question around the existing justice mechanisms on created structures where the executive, the legislature, and the criminal justice access can get together. A further question, is it time then to reintroduce what we would call a summit structure in the NCAJ where the Chief Justice, the President, and the legislature can sit and engage some of these issues? That's just one question for you. A further question to Honorable Martha Karua. This is from Felix Odhiambo. It's asking you, what do you propose as the most practical way in the current circumstances to resolve the impasse? That's for you, that's for you, Honorable Martha Karua. And to Harvey, we have a comment from one of our viewers from London asking, commenting on your statement, saying that being removed from the role of advocate engages directly with the leadership and integrity, and it is a prima facie proof of non-qualification under Chapter 6. It's a comment. So he's saying that those who think that the removal process is a waste of time, they better take heed. And then he is agreeing with your proposal that if they should put themselves up for public office, then it can be used as a basis to disqualify them for elective office. Thank you very much. Over to Zamba, Senior Counsel Zamba, and then to Honorable Martha to respond. Thank you.
The question I've been asked is whether there is a gap between the executive and the judiciary. In the Constitution, there is no gap. But it is what our President Nelson Abia said, that it is a matter of the person sitting on the seat and he not wanting to involve other players to ensure that there is harmony in governance. And it is not a matter of a law being created to allow these officers to sit together. You know, in Kenya, we suffer this thing of law after law after law. These are matters of common sense. If the President of the Republic and the Chief Justice and the Speaker are able to sit, they don't require a law around that. It is by virtue of their offices. So I would not really engage them by saying that we should now create a law that makes harmony between the offices operative. Thank you.
Yeah, I would say the way forward is for the heads of these two institutions, the executive and the judiciary, to sit and face each other on the impasse that is there. But where the matter has reached, because there is a court order, unless if there is a stay, the president would have to obey the court order, or whichever the case. But moving forward, everything cannot be resolved by the court orders. For the judiciary to resort to their own courts for orders for support in a dispute with the executive, it's not something to be encouraged. And when there is an impasse, the president being the head of the executive is the first among equals in the three arms of government. So the president has a greater responsibility to ensure that government functions. And government includes the judiciary, the legislature, and the executive. So he must confront that failure, and the Attorney General, being his legal advisor, is part of that failure. If I may comment on something that had been said earlier about the President Harvey had said about the judiciary literacy by refusing to make orders that relate to the executive. I think that would erode the impartiality or the appearance of impartiality of the judiciary and public trust. Because these wars are not personalized, I would not advocate for the judiciary to sort of go on strike. If there is an arrest warrant, it is about the public, because the complainants are the public. The republic is the people of Kenya. We cannot have a situation where the holders of office use that power to settle scores, even if those scores are institutional. So let's aim at, one, getting court orders obeyed. Number two, institutions following the law strictly. And if I may comment on something also that has not come up before, that the judiciary also has to re-examine itself. How did we reach a stage where the executive thinks it can disregard the judiciary? I think inadvertently or advertently, the judiciary may have contributed to the erosion of its prestige and trust. When they appear to cave in, when the executive backs, after the bold decision of annulling a presidential election, there have been other incidents where the perception has been that the judiciary has now been cowed. If that is the case, because I'm just saying about the perception, the judiciary needs to re-examine itself. It should not blow hot and cold, especially on constitutional matters. The interpretation ought to be consistent and not mechanistic. With regard to Chapter 6, the judiciary, that was long before Maraga, allowed people with questionable characters to vie as candidates, although Chapter 6 doesn't allow that. Many other rulings relating to Chapter 6 and other issues, including the gender rule, have shown the judiciary bending to interpret to favor the executive. These are some of the things that we must discuss openly and tell the judiciary that consistency in upholding the rule of law gets the judiciary its place and gives a warning to the executive that the judiciary is ready to guard its independence. And independence should never be equated to lack of accountability. As far as the NGOs are concerned, I think the complete letdown is some of the constitutional commissions. Civil society is doing so much. Sometimes we mistake them for the independent commissions. If I may single out the Kenya National Commission on Human Rights and the Commission on the Administration of Justice, they should by now have weighed in this impasse between the judiciary and the executive. Our constitutional commissions, some of them, have not been accountable to the public to justify the high place they have been given in the Constitution. Thank you.
Let's bring in Commissioner Dr. Marcy Ndeche, and then Nelson Harvey, you respond to the comments that was raised by our caller in London. Marcy?
Thank you very much. You were asking about the allegations of receiving inducements during the appointment selection process by commissioners. And I'll answer this together with one I've seen on the charts that says that the process, unlike the one for the CJ and DCJ interview, the process was away from the media. When it comes to inducement of commissioners during the process, I can say that I have served, I'm at the tail end of my term. I've served for over 4 years. I have never been approached, and I don't know anyone who has been approached for that kind of inducement. And when I said that Section 30 of the JS Act, although it states that the panel should be of a minimum of 5, and any commissioner can chair, I said that out of abundance of caution, the commission has organized its work in such a way that all commissioners must sit. And the person who chairs is the CJ. Now, as for inducing 11 commissioners in order to get a job, that's a pretty tall order, you'd agree with me. I don't know what nature that inducement comes, but it does not happen. There were concerns previously that there were problems during shortlisting and some applications maybe would go missing, but we have corrected that because when a person hands in the application, they have to sign somewhere, and now the shortlisting is done by individual by commissioners themselves, so that there is no mischief in the secretariat. So there is no such a thing. When it comes to the issue of the interviews were behind closed doors, that is not true. What happened is that on the first day, because of the space, the media had been asked to stay away, but after the complaint, they were brought in back. And what the media does, if it is a Marcy Ndeche whom they've never heard of, who's being interviewed, they are not going to stay there, they'll go away. But then they hear, oh, it's Justice Odunga, they'll all come. So the media were invited, but what JSC then did, it made sure that all the interviews were captured live on social media. So if you go, the person who has that question, if you go to the social media platforms, you will find all those interviews captured there. there is this talk, before I say something on the Judiciary Fund, of now people should sit together, JSC president should sit together and decide. And I ask myself, I normally ask myself, can parties sit together to disobey a court order or agree to disobey, or can they sit together to opt out of a constitutional provision? And this was the situation we found ourselves in during the retirement case of former DCJ Rawal, when there was a suggestion that we should mediate, and we were wondering, mediate so that we agree to expand the retirement date or what? Even in this case, I'm wondering what can really be done, because the court already said in the 2016 decision of the suit by LSK that the president is not at liberty to cherry pick once he gets the list. So the question, I think there are no two ways. It is for the president to do the right thing, his constitutional duty, and appoint those judges. Now, on the Judiciary Fund, this is a very sorry state of affairs, because there have been many challenges. The first one, of course, is with regard to the delay that has been there in the process of the enactment of the law and the regulations. From 2010, when the Constitution was promulgated, it took another 6 years, 2016, for the Act to pass into law, the bill to pass into law, the Judiciary Fund Act. And then it took another 3 years for the regulations to be gazetted. So that has been one of the challenges. The second one has been the effect of this statute that we call the Public Finance Management Act. The Public Finance Management Act has been injected into the Judiciary Fund Act. In Section 5 of the Judiciary Fund Act, that statute has actually subordinated itself to the Public Finance Management Act, such that the Chief Registrar, in administering the fund, must always consult or must always seek the approval of Treasury. So we have a situation where we are talking of getting independence, financial independence through this provision, Article 173, but it has been removed away at the stroke of a pen by the misalignment of the Judiciary Fund Act and the Public Finance Management Act. And right now where we are, or where the judiciary is that the CRJ has been trying her best to open an account with Central Bank, but she requires a host of approvals, courtesy of the Public Finance Management Act, from the CS Treasury to the Governor Central Bank to the Office of Allocation of Budgets. So it has not been possible. There is no account to run that fund. And the other thing we have noticed is that Wanjiko, in her creativity, pioneered this. Judiciary Fund does not exist anywhere else in the world. Kenya is pioneering, and many jurisdictions keep asking us, where are you, so that we can borrow? But we have nothing to offer, and we cannot therefore benchmark. The other problem is mindset. We have a situation where new wine is being put in old wine skins. We are dealing with people who cannot imagine a judiciary fund, like whether they cannot imagine that there can ever be another fund other than the consolidated fund. So it has been very, very difficult, and I'm glad to hear that there is that suit. So I think there is need to relook and align the PMFA with the Judiciary Fund Act for there to be judicial independence. Of course, the other problem is we get the allocation, the judiciary gets the allocation of, for now we have 18B, which is 0.6% of the entire national budget, against the best practices of 2.5%. But even this 18B is on paper. So what happens is that you are allocated, the way water is rationed, you know, you get your water on Wednesday or whatever, you are allocated that amount. It doesn't come to you, it doesn't even come quarterly. When you need, then you request for exchequer from Treasury. So what I can say is, as far as financial independence is concerned, judiciary is at 0. And you know, the person who has the pass now calls the shot. Of course, we have the problem also of sudden and arbitrary budget cuts without any consultation. That still happens. And that really impedes and affects the work of the judiciary. So I would really call upon ICJ and other stakeholders to really focus on this issue of judiciary fund, because I can say for now, there isn't much goodwill, and the mindset is the old mindset. And I am hopeful that we will get somewhere, but there is no light. I cannot see much light at the end of the tunnel. Thank you very much, Patrick.
Harvey, you're running short of time.
Yeah, thank you, the caller from England. I appreciate the comments you've made. I think the primordial question we have to face now is Chapter 6. And the urgent question is this: what do you do with a court order when the executive says utadu? And remember, these lamentations is one that has been with us for a while. Chief Justice retired William Mutunga had the same lamentation. Chief Justice David Maraga has the same lamentation. We cannot babysit court orders, to quote Justice Odunga. We need to find a solution out of this matter. It's quite evident that the President of the Republic of Kenya has been embarrassed by his chief legal officer. How do you get out of this embarrassment, Your Excellency? Do the right thing. Swear in the 41 judges as soon as possible. If you have a problem with any of the judges, originate complaints against them before the Judicial Service Commission. I guarantee you, as the Law Society of Kenya, we will be behind you if there is any evidence to indicate that some of those judges are not suitable to serve. But the judiciary is not without reprieve. The Chief Justice must do the correct thing. Ensure that your judges do not bend backwards. As Martha Karua said, judges have some responsibility for the problem we have right now. What have we done about the many decisions on the 2/3 gender rule? The Chief Justice must do the correct thing. If the law demands that you write to the President to dissolve Parliament, the Chief Justice must do this, because it does not solve the problem for the Chief Justice to descend the staircase of justice and come and cry when on his part, he has not done his part. Because it is quite apparent that many of these things will not be resolved through the court of law. Let us resolve them through avenues that are available within the Constitution for us to progress. For a fact, Chapter 6 must be enforced now for Kenya to prosper. Thank you.
President, we have a caller, Evans Monari, wants to call in and make a comment and pose a question. Evans Monari, if you're on the line, please pose your question to the panelists.
I don't know whether you can hear me.
Hear you, Mr. Monari.
Okay, in light of what has been said, and first of all, let me thank the speakers. Very illuminating remarks have been made. To what extent does the current JSC take responsibility for this impasse?
Very much, Mr. Monari. That question, we'll address it to Mercy, if he can respond, and any other panelists.
I have asked myself that question, and I cannot take, the Commission cannot really take responsibility for impunity by another person, and especially when there is a pattern of that behavior. Like I said, this is not the first time. It happened in 2015, and it is happening again now. So if there was any wrongdoing on the part of the Commission, would be the first to stand up and say, yes, we did the wrong thing here. But we have even looked backward and said, what could we have done differently? Nothing. There is nothing you can do about a person who is not doing what they are supposed to do after 15 judges have said this is what they are supposed to do. Thank you.
Thanks. Yeah, thank you very much, Mercy, for that, and thank you, Mr. Monari, for calling in. Now we're going into the sessions where we are winding up our webinar for this afternoon. Thank you very much. So we'll invite the panelists to each give us their parting shot We'll start with Senior Counsel Nzamba, then Honorable Martha, followed by Mercy, thereafter the Law Society President Nelson Harvey, and then we'll, last but not least, our very own chairman. Then we can go into the concluding session. Thank you very much. Welcome, Senior Counsel.
I want to thank all participants for their contribution, which have enlightened all of us on what needs to be done. I also want to say this, that the much talked about legacy of the president when he's leaving office must also include his role in the appointment of judges. So those of us who are able to talk to him must make him understand that this is also part of his legacy. He should not go down as the president who disabled the justice system. Finally, I would like maybe that we have this opportunity to reflect on reforms that are contemplated in the near future. I want to remind us that when we were drafting the Constitution, we had the harmonized draft. And I want us to all take time to look after that draft. And you will find that in the governance system, we had provided for a hybrid system of government, which included the president, a prime minister, leader of the opposition, and we had also said that ministers can also come from parliament. I want us to reflect whether we can, again, see if those provisions can be enacted in the proposed changes. Because these are suggestions which had been made by Kenyans, even at Naivasha, but they were cannibalized by the Naivasha committee. Can you reflect on that, please? Thank you very much.
Thank you, Senior Counsel. We invite Honorable Martha Kalua.
To unmute. Yes, I am.
Can't hear you.
Sorry, Martha, we can't hear you.
So sorry, let me unmute. Oh, it is now unmuted.
Yes.
Thank you.
Okay. I want to say, to begin with, that like the president, I discern a constitutional moment, but not a moment to start cannibalizing a constitution we have yet to fully implement. I see a moment to accelerate the implementation of the Constitution. So let us first finish the unfinished business. And the standoff we are having is not because of the Constitution. It's because of the failure by those holding positions of authority to actually obey the Constitution. We have no guarantee that if we accede to their demands of amending the Constitution, they will now obey. Let us have a culture of upholding the rule of law. I had said about the judiciary. Let me talk about the JSC. When there is a complaint before the JSC against a serving member of the judiciary, it is the duty of the JSC to see that the complaint is dealt with in an expeditious manner. Failure to do that erodes confidence. Currently, the JSC has had pending for the longest the complaint against the DCJ, against the CJ himself, and against various other judges. I know the DCJ matter is in court. There, the judiciary then should have accelerated that matter to its conclusion so that she's either vindicated or whatever the outcome. And that goes for every judge. So when Dr. Deche says the JSC has no blame, all these things weigh in on the JSC. And then the question comes, when the executive, if at all, approached the JSC in this case and said, we have information regarding XYZ, did the JSC demand full information from the executive? If they did, then they are not to blame where the executive fails to provide the information. I'm of the view that even if the JSC receives information from a member of the public, even at a belated stage, it ought to be rechecked so that we do not contravene the Constitution in having people who are not suited. But it must not be a frivolous piece of information. It must not be oblique. So I would end by saying, let us all re-examine how best we can help to strengthen our institutions, to uphold the rule of law. And I do agree entirely. If there is an order, a court order, it must be obeyed. Unless if a stay has been obtained, and in this case, I don't think there is any stay, the court order has to be obeyed. And then we can deal with the aftermath. So let us keep the channels of communication open. And I want to end by thanking ICJ, my fellow panelists, and all the participants. We have to keep speaking to one another, finding solutions to the problems that are in our nation. Thank you.
Thank you, Martha. We welcome Mercy.
Thank you very much, ICJ and my fellow panelists. My parting shot is, let us remember where we've come from in terms of judicial independence and where we are going, and put everything into context. If we have a situation where people are nominated and then the appointing authority says they are tainted, how far will we go? And remember, there are soon going to be other more recruitment, or especially to replace the Supreme Court judge, and eventually when the CJ leaves, what if we find ourselves in the same situation? So this goes to the very core of the rule of law and very serious issues that are very key to our constitutional democracy. Because if that happens, when will we ever hear the last of this? As far as the issue of calling for reforms and to the Constitution is concerned, I associate myself with my seniors, Martha Karua's sentiments. I don't think this is the time. And I would especially not really, for my part, not want anyone to tinker with the architectural design of the judiciary at this time. And why? Because you do not even fix a roof when it's raining. This time it is raining, and it's raining heavily. So calling for reforms and who should sit and who should not is quite dangerous. And lastly, I want to assure my senior that the JSC is trying its best to hear and determine all issues that are there before it. What normally happens is that petitions are filed with so much fanfare, but on the same note, the same people withdraw them very quietly. So the country never gets to know. But I got your message loud and clear, and I appreciate this forum. And I'm sure as we continue with the conversations, we are going to get better. Thank you very much.
Now to Nelson Harvey, the LSK president. Your closing remarks, please.
Friends, Kenyans, August 2020 will mark 10 years since the promulgation of the current constitution. How have we progressed under this constitution? Has the democratic space expanded? Have we received optimal use and service out of this constitution? Where is the problem? For a fact, there is a problem. And what is the problem? Is it a problem that requires amendment, or is it a problem that requires implementation? Last year in August, at the annual conference of lawyers, the unanimity of voices was this, that the current constitution as it is suffers no problem that requires amendment. It suffers a big problem that requires implementation. That is where we are right now. Lawyers, members of the public, and the judiciary, we must play our respective role. Let me also remind our colleagues in Parliament that it is incumbent upon them as elected representatives of the people with the benefit of legal learning to do the correct thing. What about the judiciary? for now, we've initiated the process of expulsion of the Attorney General and the Solicitor General from the membership of the society. Why? Because they have misadvised the President of the Republic of Kenya. They have prevailed in the disobedience of court orders. I'm sure in the next few days, they will rush to court seeking reprieve. It is upon you to look at this matter and determine how to evaluate and deal with the conduct of these individuals. But as members of the Law Society, I beseech you to turn out in large numbers on the 23rd of July and make a decision on whether or not you want these two members to remain as members of the Law Society or to be expelled. My parting shot is this. We have made very good furniture, and this furniture is the Constitution of Kenya 2010. The furniture is aging well. Several people tend to sit on the big seat. Other people sit on the other seats on the table. What is the problem? Is the problem the seat or the person sitting on the seat? When it comes for us to appoint other people to sit on those seats, let us take into account chapter 6. When it comes for the election of people to occupy these seats, let's look at chapter 6, because we'll not be able to go forward unless we see where we've come from and where we are. That, friends, that Kenyans, will be the solution to the problem that requires change for now. Thank you so much. God bless you. God bless Kenyans.
Thank you very much. All good things must come to an end, including this webinar. I think as Kenyans, as lawyers, as civil society, as LSK, we are called upon at this point in our national history to defend the Constitution, because it is under attack by an overreaching executive. At the end of the day, the people of Kenya, the judiciary, in the words of Dr. Martin Luther King, will remember not the words of their enemies, but the silence of their friends. At this point in time, let me invite our chair, our president, Kevin Bugeni, to give his closing remarks. And thank you very much. And I also thank my fellow moderator, Elsie Saina, for it was our pleasure to moderate. Asante sana. Kevin.
Thank you, Patrick. What we have is an assault on everybody, and as a country, we are at a very difficult time. More so when the Constitution is under attack by persons who have failed to implement the Constitution as it is. As civil society, we made all efforts to ensure that our voice is heard. We have been trying to ensure that we've done it with civility, in all fairness. And I think it is time for now to rise up and ensure that the public and other persons join us in ensuring that the executive and those who are violating our Constitution hear our voices. And I think it is time now, we may have to start, apart from issuing the ultimatums that we have done, to continue with the necessary demonstrations, if need be, to ensure that the public is synthesized, to also participate in the process that we have started. I've heard from the speakers so far and what we have had in these discussions, in that, as part of the process of the civil society, this particular webinar that we are hosting, it is one testimony that is showing that we have tried as much as we can to ensure that the public and everybody else is able to be sensitized to know what is going on and what's ailing our society. We must remember that our aspiration as an organization, our aspiration as an institution, is to ensure that we have a just, free, and equitable society. This is because we know that laws universally must be applied to everybody in equal measure. If any provision applies to you, that is what you must do to ensure that that is applicable to you and everybody else. In making the closing remarks in respect in this webinar, I need to thank all the panelists that we have had today: Senior Counsel Zamba Kitonga, Honorable Martha Karua, Dr. Mercy Leche and President Harvey, it has been restated from the discussion that the framers of the Constitution, and by extension the people of Kenya, intended to enhance the separation of powers in order to safeguard the executive against executive excesses. The independence of commissions and independent officers is critical in the performance of their functions. Therefore, an independent judiciary should and must have control over financial resources, which it requires to fund its operations. A proportion of the government's revenue should be dedicated to the judiciary operations and should be payable outside the framework of periodic approvals. Moreover, the president's inordinate delay to formalize the appointment of judges undermines the constitutional role of the Judicial Service Commission, which is to safeguard and promote the independence of the judiciary. The appointment of judges by the president should be immediate and should be as soon as the recommendations are forwarded to him by the commission and within reasonable time. ICJ Kenya will continue to defend the independence of the judiciary and promote mechanisms and enhance accountability within the judiciary and in Kenya and within the region. On behalf of the ICJ Kenya Council and the Secretariat, I extend my sincere gratitude to our distinguished panelists and allow them for their continued support and commitment to the promotion of and protection of judicial independence and accountability in Kenya. Thank you all, and God bless you.